Rachel Munt almost didn't go down to the cellar that morning. She had other things to see to first: the fire, the breakfast things, the ordinary sequence of tasks that structured a housekeeper's morning. But something pulled her down those stairs anyway. A sound, perhaps, or the absence of one. She went down, and what she found at the bottom changed everything about the quiet household above her. Christiana Christmas-Sommer was dead. She was 10 years old, and until that morning, almost nobody outside these walls had known she existed. What followed moved from that cold cellar in Victorian England all the way into a courtroom, through years of legal argument, and eventually into the kind of record that outlasts everyone connected to it. But before the verdict, before the arrest, before any of it, there was just a housekeeper at the bottom of a flight of stairs, looking at something she could not unfind. These are 3 cases, 3 moments when ordinary life split open to reveal what had been sitting underneath it. The woman in the first case had spent years building a reputation on composure. The man in the second was trusted with the keys to a church. The woman in the third lived on a quiet rural road in Scotland where nothing much happened, until the morning it did. What connects them is not the violence itself. What connects them is the silence that followed, the investigations that ran into dead ends. The trials constructed on evidence solid in some places and dangerously thin in others. The verdicts delivered by courts that believed their job finished the moment the paperwork was filed. They were wrong, but they didn't know it yet. What these 3 cases share is also something about the people who got caught inside the machinery of 19th century criminal justice. A machinery that was efficient, that was procedurally serious, and that was almost entirely uninterested in the circumstances surrounding the events it was asked to adjudicate. Courts in this era were built to determine guilt and assign punishment. They were not built to ask why, or to consider whether the answer to why might change how the verdict should be weighted. The why was someone else's problem, and in practice it was often no one's problem at all. It went unexamined, or it was examined in the brief window of a petition campaign after the verdict, and then it was filed away with everything else. The cases that follow were not unusual for their time. They were handled by the standards in use, evaluated by the tools available, and closed with the confidence that attaches to official conclusions. What makes them worth returning to is not that they were exceptional. It is that they were ordinary examples of what the system produced when it worked exactly as it was designed to work. And yet ordinary here does not mean small. A 10-year-old girl died in a cellar. A 5-year-old was found in a church belfry she had no reason to be in. A woman on a moorland road was killed in her own farmhouse on an ordinary morning. The people at the center of these cases lived full lives before the events that made them case files, lives that the legal proceedings captured only at their most extreme and most final moment. What the records hold is the crisis. What they don't hold is everything that preceded it, the daily routines, the relationships, the small decisions, and accumulated circumstances that led, eventually, to the moment the record begins. That is the part that disappears. That is what it costs to be remembered only as a case. Celestina Sommer was, in a language her neighbors would have used, a respectable woman. This meant specific things in mid-Victorian England. It meant she kept her house in order. It meant she conducted herself in public without giving anyone cause to talk. It meant she presented consistently and without visible effort the image of a woman who had her circumstances under control. The image was not entirely false. What it omitted was the thing that eventually changed everything. She had a daughter, Christiana Christmas-Sommer, born outside the circumstances that made a child's existence socially uncomplicated in that era. Celestina had managed this with the same measured composure she brought to everything else. Not hidden, exactly. Managed. The child was there. She simply wasn't there in any way that invited open discussion. She moved through the household quietly, at the margins of the life Celestina showed the world, 10 years old and living in a space between acknowledged and invisible. What that life looked like for Christiana on an ordinary day is something no surviving document can describe in detail. She was 10, which meant she was old enough to understand, in some imprecise way, that her situation was not the same as other children's. Old enough to have learned what questions not to ask, which conversations to leave the room for, how to read the specific texture of quiet that descended when certain subjects came close. Children in that position learn these things not because anyone teaches them explicitly, but because the household teaches them through repetition, through the pattern of what gets said and what doesn't, what is acknowledged and what quietly disappears. Christiana had been absorbing this pattern for her entire life. She had never known anything else. The house itself would have looked entirely ordinary from the outside. A decent address, curtains drawn to a proper length, the kind of front door that suggested nothing unusual happened behind it. Inside, a different kind of arithmetic was always running. Who knew how to manage the difference between what was known and what was visible? Celestina had been running that arithmetic for a decade by the time Rachel Munt went down to the cellar. When Rachel came back up and told Celestina what she had found, that composure did not immediately break. Celestina was still, contained, the kind of stillness that can mean shock or grief or something the law would later argue is neither. Witnesses would describe her as calm. The prosecution would take that same word and hand it back to the jury as evidence of coldness. Whether it was either of those things, or whether it was simply the response of a woman who had spent 10 years training herself to control what her face showed in difficult moments, is something no court proceeding could fully resolve. The examination of Christiana's body established that this had not been an accident. The injuries were not consistent with a fall or with illness. There was no way to explain what the examination revealed without placing another person in that cellar. The circle of people who could have been that person narrowed fast. It narrowed, in the logic of the investigation, to one. And that one person was the woman upstairs, who had not immediately broken down when Rachel Munt came up from below, whose composure was being reconsidered by everyone who had ever taken it at face value. The neighbors had sensed something was off long before the arrest. They always do, not specifically, not with names attached, but with that ambient awareness that settles into a street when something nearby is being carefully not discussed. The daughter who was never fully explained. The controlled way Celestina managed what people knew about her private life. After the arrest, people found themselves reinterpreting old observations. Weeks of small, unremarkable moments suddenly looked different with a police inquiry running through the middle of them. A hesitation that had seemed like shyness began to look like concealment. A closed door that had seemed like ordinary privacy began to look like something that needed to stay closed. At trial, the prosecution built its case around access, proximity, and the absence of any other plausible explanation. The defense countered with something just beginning to find its footing in Victorian legal thinking. The argument that a woman carrying the full weight of social disgrace alone, living under constant threat of exposure, managing an impossible situation without support, with no legitimate path to public acknowledgement of her own daughter, had been operating under pressure that the law simply wasn't built to measure. It was an argument ahead of its time, which meant it was an argument the jury was not yet equipped to fully receive. The courtroom in Victorian England operated as a space designed to enforce its own moral categories. Women who had transgressed the boundaries of respectability were understood, in that room, through a particular lens, one that made it very difficult to separate the crime on trial from the broader failure of character that the circumstances of Christiana's birth were taken to represent. Celestina had committed 2 offenses in the court of public opinion. She had produced a child outside of marriage, and she had concealed it. The jury was being asked to evaluate the second offense without those facts quietly coloring their judgment of the first. That was an impossible instruction to follow, and the defense had no real mechanism to enforce it. The prosecution needed only to establish that Celestina was present, that no one else had access, and that the injuries on Christiana's body were inconsistent with any accidental cause. On all 3 points, the evidence was sufficient. The deeper question, what had actually taken place in that cellar in the hours before Rachel Munt made her discovery, was one the court could not answer with any confidence, and did not need to answer in order to return a verdict. Courts are not always pursuing full truth. Their task is sufficient proof, and sufficient proof was what the prosecution had provided. They found her guilty. What followed the conviction was a quieter legal battle running alongside the formal sentence. Petitions circulated. Medical professionals offered opinions on her mental state that went beyond what the trial had considered. Advocates argued that the court had processed Celestina too cleanly, without enough weight given to the conditions that had surrounded her. Some of this came from genuine doubt about exactly what the final hours in that cellar had looked like. Some came from a growing Victorian discomfort with watching the machinery of criminal justice operate on women whose circumstances that same society had helped engineer and then refused to accommodate. The medical argument was the most persistent. Several physicians of the era were beginning to articulate, carefully, in language calibrated not to outpace what courts were ready to accept, the idea that the mental state of a person living under sustained and extreme social pressure was not simply a mitigating factor, but a condition that altered culpability in ways the existing framework of guilty or not guilty couldn't adequately capture. Celestina Summers' case was one of several that advocates in this emerging conversation pointed to as evidence that the law needed better tools for distinguishing between different kinds of criminal intent and different kinds of human circumstance. The argument was real. It simply arrived too late to do Celestina any concrete good. None of it moved fast enough. Celestina Sommer died in custody. The sentence had been commuted rather than carried out. She was not to be executed, but she never made it out. Time ran out before any of the arguments made on her behalf could change the practical reality of where she was. She died in prison, having been convicted of killing the daughter whose existence she had spent a decade trying to protect, in her own particular way, from a world that had no good place for either of them. The file closed. Christiana Christmas Sommer was 10 years old. She had lived quietly in that house for a decade, at the edge of a life that wasn't prepared to admit she existed publicly. The tragedy layered into this case is not simply that she died, or that the full circumstances of her death were never clearly established at trial. It is that the system which punished Celestina for what happened in that cellar was the same system that had made Christiana's existence something to be concealed rather than supported. A different set of social arrangements, ones that didn't treat illegitimacy as a sentence, that gave women in impossible situations somewhere legitimate to turn, and Christiana Christmas Sommer might have grown up. She might have had a name people knew openly. She might have had a life rather than a secret. The verdict addressed the death. It addressed nothing about the conditions that had made the cellar necessary. That is what the closed file carries without knowing it. The shape of a much larger failure compressed into a single, final judgment. Composure was Thomas Piper's camouflage too, but his was the composure of institution rather than individual. He didn't need to carefully manage what people thought of him. The church did that work automatically, simply by employing him. In the spring of 1875, the belfry of the Warren Avenue Baptist Church in Boston held a secret that would shatter a community's sense of what safety actually meant. And Thomas Piper, who held the key to every door in that building, was the only person who could have put it there. The Warren Avenue Baptist Church was the kind of institution that gave a community its sense of itself. Churches were where you sent your children when you wanted them safe. They operated on a specific unspoken agreement. Bring your family here, and the building and the people inside it will return them to you. Boston in 1875 was a city with strong faith in its institutions, in the mechanisms of civic life that structured the week and gave it its shape. Sunday school was not simply a religious exercise. It was a social ritual, a demonstration of belonging, a way that families participated in the life of the community they lived in. Sending your child, there was an act of trust in the fullest sense. Trust in the institution, trust in the people the institution employed, trust in the basic reliability of the world you had built your life inside. Mabel Young was 5 years old, and she liked pigeons. She had been watching them on the church roof before her Sunday school class, the way children that age approach a Sunday morning, with far more genuine interest in the birds above than in whatever lesson waits inside. She had a habit of tilting her head back to track them along the gutters and the ridge line, losing interest in whatever adult conversation was happening beside her the moment a pigeon landed somewhere new. She attended her class that morning. When it ended, the other children went home. Mabel didn't come home. Her mother waited. The afternoon stretched past the point where waiting felt ordinary, into the particular quality of dread that sets in when you've checked every room twice and called every neighbor, and the explanation you kept telling yourself must exist simply isn't there. The search moved beyond the house and into the street, from the street to the church, from the church's public spaces into the parts of it that a 5-year-old had no reason to have found on her own. When the search finally reached the belfry, up a narrow staircase in a part of the building that required knowledge to find, they found her alive. She did not stay that way. The medical examination delivered what no one in that community wanted to formally receive. This was not a fall, not an accident. Whoever had done this had moved through the church without drawing attention, knew which spaces provided cover, accessed areas that weren't open to the congregation on a Sunday morning. The familiarity required was not the familiarity of a visitor. It was the familiarity of someone for whom every corner of the building was occupational territory. For Sexton, the belfry staircase was simply another corridor to maintain. Thomas Piper had been at Warren Avenue for years, trusted in the deep, unreflective way that people trust figures who maintain the institutions they depend on. He blended into the building so completely that people had stopped registering his presence as something worth noticing. He had keys to everything. He knew every back staircase, every room that sat empty on a Sunday morning while the congregation filled the pews below. His presence anywhere in the church required no explanation, because explaining himself was not part of his job. His job was simply to be there, in the parts the congregation didn't go, keeping everything running. The investigation moved toward him through accumulation. Inconsistencies in his account of that afternoon. Physical details that refused to align cleanly with what he said, behavioral responses that investigators kept circling back to in the days that followed. Each individual element could be argued around. Together, they formed something that couldn't be stepped around without significant effort. The first trial ended in a hung jury. 12 people looked at the same chain of circumstantial evidence and couldn't unanimously agree on what it demanded. Some believed the inference was clear and unavoidable. Others weren't willing to send a man to execution on inference alone, however carefully constructed. The jury deadlocked. Piper was remanded to await a second trial, and Boston waited with him, unsettled in a way it hadn't been before, and not quite able to return to ordinary life while the question remained formally unresolved. In the months before the second trial, investigators developed connections between Piper and the earlier death of Bridget Landregan. Another victim, a pattern assembling itself in public view, piece by piece. By the time the second jury convened, Piper was no longer simply the accused in one case. He had become a figure the city had spent months looking at differently, with the particular queasy discomfort of people who realized they extended deep trust to someone who had no right to it, and who used that trust in the worst possible way, in the most protected space available to him. The second trial reached a different conclusion. Thomas Piper was found guilty and executed in 1876. The coverage ran in Boston newspapers for months. Editorials moved beyond the crime itself into something closer to civic self-examination. What did it mean that this had happened inside a church on a Sunday morning, carried out by the man whose specific responsibility was to keep the building and everyone inside it safe? The wound wasn't only the violence done to a 5-year-old child looking for pigeons on a spring morning. It was the discovery that institutional trust and actual safety were different things, and that the gap between them had been wide enough for something terrible to move through it, undetected, for long enough to matter. Part of what made the Piper case so disorienting for Boston was that it didn't fit the shape of the crimes people knew how to mentally process. Danger was supposed to come from the margins, from strangers, from people on the wrong side of the city's many social dividing lines. Thomas Piper was not marginal. He was embedded. He attended the same church he was accused of defiling. His name was on employment record in a respectable institution's files. His daily presence in that building was not suspicious. It was contractual. The city had paid for him to be there. This is what made the first hung jury comprehensible in retrospect. Not that 12 people found the evidence insufficient, but that they struggled with what conviction would require them to believe about the world they lived in. Conviction meant accepting that the sexton of a Baptist church had committed an act of extreme violence against a child in the building's belfry on a Sunday morning, with the congregation one floor below. It meant accepting that a trusted employee in a trusted institution was dangerous precisely because the institution trusted him. That is a belief that changes how you move through the world, and people are understandably slow to adopt it. The second jury adopted it. and Boston, after the execution, tried to return to normal, and largely succeeded, the way communities always largely succeed, because the alternative is a level of vigilance that can't be sustained alongside ordinary life. But something had been demonstrated that couldn't be undemonstrated. After the execution, the alarm faded, as alarms do when they've been given a conclusion. The church stood. Families kept sending children to Sunday school. Life returned to its previous shape, almost. There was something in the texture of that trust that didn't fully restore itself. A small, permanent knowledge deposited into a community's understanding of itself, purchased at the worst possible price. That the guarantee of safety offered by an institution is a social agreement rather than an operational certainty, and that the person holding the keys is a human being regardless of what the title on their employment says. Mabel Young was 5 years old. She had been watching the pigeons. She never came home. 3 years before Mabel Young went looking for pigeons on a Boston church roof, in a stone farmhouse outside Cellar, Dumfriesshire, a woman named Hannah was found dead. The details were not subtle. Blunt force violence, delivered with enough force to leave no ambiguity about intent. The interior of the farmhouse showed clearly what had happened in the minutes before the end. What the scene couldn't show was who had done it. And in a rural community in 1862, scattered across moorland where the distance between properties was measured in walking time rather than city blocks, that question had to be answered through proximity and inference. Dumfriesshire in this period was a landscape of practical isolation. The moorland roads connected settlements that were small enough that everyone on them was known, and far enough apart that daily life unfolded largely without witnesses. The farmhouses had a self-contained quality born from necessity. You managed your own affairs because there was rarely anyone close enough to help quickly, and you knew your neighbor's business because that knowledge was part of how rural survival worked. These were communities held together by familiarity and proximity in equal measure, and the same familiarity that made them coherent also meant that conflict between neighbors had no easy exit. There was no moving away to somewhere new. There was only the road, and the same faces on it every day. There was no anonymous foot traffic on that road. People who came to your door were people whose faces you knew. Whoever had stood at Hannah's threshold that morning had been close enough, familiar enough, that their presence on that particular stretch of road would not have struck anyone watching as out of the ordinary. Mary Timmy lived nearby. She was known in the community the way people in small rural settlements are always known, not intimately, but unmistakably. Her name was familiar. Her face was familiar. The path between her property and Hannah's was not a long one. And when investigators examined her clothing and her belongings, they found details that placed her, in their reading of the evidence, in connection with what had happened at Hannah's home. Among the items that drew particular attention were pieces of clothing and a tea caddy, small, ordinary objects in themselves, that became significant the moment their origin needed to be accounted for. They had not, investigators believed, come from Mary Timmy's own household. The question of where they had come from pointed in a direction she could not satisfactorily explain away. This kind of physical evidence, items that connect a suspect to a scene without placing them there directly, was the currency of rural criminal investigations in this period. Fingerprinting did not exist. Forensic pathology in its modern form did not exist. What existed was careful examination of physical objects, the testimony of neighbors who knew what belonged to whom, and the patient reconstruction of who had been where and when. In a small enough community, this method had real traction. Everyone knew what their neighbors owned. A tea caddy from Hannah's kitchen, found in Mary Timney's possession, carried a weight of implication that it would not have carried in a city of strangers. Combined with the inconsistencies in her account of her movements that morning, the case against her assembled itself with a logic the court found convincing. She was arrested, charged, and brought to trial. And at trial, Mary Timney did not simply accept the prosecution's account. She raised a self-defense claim, the argument that what had passed between her and Hannah was not the unprovoked assault the prosecution described. There was a history between these two women, as there tends to be between neighbors who have shared the same road, the same small community, the same limited social world for years. The specific nature of that history, the circumstances Mary Timney argued had made her actions defensive rather than predatory, were raised and examined. The jury set them aside. Guilty. Death. The self-defense claim deserves more than the dismissal it received, not because it can be verified at this distance, but because the dynamic it described, a dispute between neighbors in a rural community escalating past the point of control, was not implausible on its face. Rural Dumfriesshire in 1862 was not a landscape where conflicts between neighbors had easy resolution. There is no intermediary authority to call, no simple mechanism for reporting grievances or seeking mediation. Disputes between people who lived on adjacent properties, who saw each other regularly and had no way to avoid each other, could accumulate over years and into something that had no safe outlet. Whether that is what happened between Mary Timney and Hannah is not something the surviving record can confirm. What the record confirms is that the court heard the claim and chose not to credit it, and that the choice was final in the most complete sense available. What followed the verdict was something the formal trial record understates considerably. The petitions began almost immediately, and they spread. Across Dumfriesshire and beyond, people who had followed the proceedings in newspapers, who had formed their own judgments from the coverage and from what they felt when they read it, added their names to documents arguing that executing Mary Timney would be wrong. Some believed the verdict itself was a mistake. Some believed the self-defense claim had been dismissed without the consideration it deserved. Some believed, and were finding it increasingly difficult to push this belief aside, that the spectacle of a public execution, a woman hanged in a Scottish town square before a crowd, was inconsistent with what they wanted 1862 Scotland to be. The campaign reached officials at every level. Medical men submitted formal letters. Clergy added their voices to the argument. And then the provost of Dumfries, the most senior civic figure in the very town where the execution was scheduled to take place, formally pleaded for her life. This was not a fringe petition gathering names from the fringes of public opinion. This was the community's own leadership turning toward the decision-makers and asking them, in the plainest terms the formal channels allowed, to stop. The decision-makers did not stop. On May 29, 1862, Mary Timney was publicly hanged in Dumfries. She was the last woman to be publicly executed in Scotland. The crowd that gathered that May morning was large. Public executions in Scotland had always drawn significant audiences, the spectacle of state punishment functioning as civic ritual and deterrent in one. But the crowd at Mary Timney's execution was described in newspaper accounts as markedly different in tone from earlier such events. Something had shifted in what people expected to feel when they arrived, and in what they actually felt when it was over. The petitions, the provost's letter, the weeks of public debate about whether this should happen at all, these had primed the audience in a way that made the execution feel less like justice being administered and more like something being carried out over their objection. The ritual of public punishment was meant to produce consensus. In this case, it produced its opposite. That outcome, more than any petition, was what ended the practice. That designation, the last, is what kept her name from fading entirely. History pays attention to endpoints because endpoints mark thresholds. Before this morning, public execution of women was something Scotland did. After it, Scotland stopped. The petitioners couldn't save her. Neither could the provost. But the revulsion that spread through that crowd in Dumfries became the argument no legislature could ignore. She stands on that threshold without having chosen it, and standing there gave her nothing at all. What the designation of last doesn't do is restore the fullness of who she was before the trial made her famous in the wrong direction. It preserves the milestone. It compresses the person into it. Mary Timney becomes the last rather than a woman from Dumfriesshire who had years of history on that rural road, who had a specific account of what had happened with Hannah that the court declined to fully credit, who had people, the provost, the petitioners, the letter writers, who believed she had been wronged by the verdict and tried, in the time available to them, to say so through every formal channel that existed. And Hannah deserved more than the documentation history gave her. The woman whose death set all of this in motion appears in the surviving record as the occasion for proceedings rather than a person whose daily life had weight and texture before the morning had ended. What she was doing when the knock came at her door, whether she recognized the face outside before she opened it, what the last ordinary hour of her morning looked like, the record does not say. She is there as a death requiring a verdict, and after the verdict, she recedes. Her name appears in the trial record, in newspaper summaries of the case, in the historical footnotes that mention Mary Timney's designation as the last publicly executed woman in Scotland. It appears as a reason rather than a subject. And Hannah, who lived on that moorland road and managed her own farmhouse and had whatever daily routines made up her life in rural Dumfriesshire in 1862, she is in the record the way a threshold is in a building plan, essential to the structure, invisible in the finished room. That is its own kind of injustice, quieter than the one the court was asked to address, but no less permanent in what it takes away. The silence in the belfry. The cold at the bottom of a flight of cellar stairs. The morning light falling across the entrance of a moorland farmhouse in Dumfriesshire, where a woman answered her door and didn't survive the hour. These are the places where these three stories actually live. Not in the verdicts, not in the execution dates, not in the formal and efficient language of proceedings long since closed. There is a version of each of these cases that the official record tells cleanly. Crime committed, suspect identified, evidence gathered, verdict returned, sentence carried out. That version is accurate, as far as it goes. What it doesn't tell you is what it cost to arrive there, not in legal terms, but in human ones. The cost to Christiana Christmas-Sommer of living as a secret. The cost to Mabel Young's mother of an afternoon that never resolved into a simple explanation. The cost to the people of Dumfries of being made to watch something they had formally asked to stop. Official records are very good at logging conclusions. They're not built to carry the weight of what the conclusions meant. What each of the three cases left behind was different, and that difference matters. Celestina Sommer's case left behind the unresolved question of what justice looks like when the conditions that produce a crime are conditions the law helped build. Christiana Christmas-Sommer existed in concealment because concealment was the only option a Victorian woman in her mother's situation had. The verdict addressed the death in the cellar. It left untouched the social architecture that had put both of them there, that had made the secret necessary, that had given Celestina no legitimate path, and Christiana no acknowledged life. The court processed the outcome of that architecture without ever examining the architecture itself. This is what the file carries without knowing it. Not just a verdict, but an entire system of social conditions that produced the verdict and then walked away, satisfied, leaving both of them behind. Thomas Piper's case left behind a permanently altered form of institutional trust, not destroyed, but cracked in a specific and located way. The Warren Avenue Baptist Church stood after 1876. Parents kept bringing their children back every Sunday. But the belief that safety is guaranteed by setting rather than by the actual character of the people inside that setting had been exposed as the assumption it always was. The wound Piper left in Boston's sense of itself was not so large that the city couldn't function around it. It was small enough to live with, and large enough never to fully close. Every institution that employs people and extends trust to them on the basis of that employment inherited from cases like this one, a question it still hasn't fully answered. How do you verify the character of the person holding the keys when the institution itself provides the cover? Mary Timney's case left behind a shift that came too late for her and arrived in time for everyone who came after. The execution proceeded. The petitions failed. The provost's letter went unanswered in the way that counts. And then, in the years following, public execution of women in Scotland stopped. Not by a single legislative act, but by the accumulated weight of what the Dumfries execution had demonstrated. That the public no longer endorsed the ritual, that the crowd gathered to witness justice had left feeling something other than satisfied. The law moved in the direction the provost had been pointing, reached the destination he was describing, and found that the woman on whose behalf he had written was not there to see it. This is how legal change tends to work. The argument wins eventually. The person who made the argument necessary does not always survive to see it won. These cases didn't get the documentaries or the anniversary retrospectives. They got filed, and the filing held. But there's a difference between a closed case and a finished story, and the difference lives in the gap between what the law recorded and what the law never thought to ask. A child hidden in the margins of a respectable household, who never got to be anything else. A church belfry that wasn't safe on a Sunday morning. A moorland road that kept its secrets better than the courts kept their promises. The verdicts addressed the deaths. They left everything else exactly where they found it. The provost's letter is probably still in a drawer somewhere. Formally rejected, perfectly preserved. Christiana Christmas Summer's name is in a court file. Mabel Young's age is in a newspaper archive. And Hannah's address is in an inquest record. The cases were closed. The names were not lost. It is not nothing to go back and say them.